Journalism is a fundamental necessity. So is the right to free speech and the need to be heard. But the unfettered freedom to say, show, depict, share, or broadcast whatever content, when and how, cannot be accepted in any civilized society. Neither can the powerful dominant forces of politics, elitism, gag the voices of dissent in the name of regulation. Freedom of the press to broadcast views, issues, ideologies, beliefs, and sometimes whimsical emotions have often come against the impassable giant walls of censorship and unbridled regulations, which are sometimes well-intended and righteous and other times capriciously designed to suffocate the voices of opposition. I do not stand under any illusion that all is well with broadcast content on the Ghanaian media landscape, so something should be done to purge the system. In the case between the Ghana Independent Broadcasters Association, GIBA, and the National Media Commission, NMC, a justice of the Supreme Court, Benin JSC, said, and I quote, "It is clear, even from a cursory reading of Regulation 3 of LI 2224, that there is clearly a case of censorship contrary to Article 162 of the Constitution." Goes on to say that regulation will have the effect of stifling diversity of ideas and lead to standardization of ideas like what happens in dictatorships and communist societies, end quote. As a broadcast journalist, my antenna of query gets erect when I hear of the political elites framing laws that aim at sanitizing the broadcast space. So I am persuaded tonight to ask where the middle ground between regulation, censorship, or an elusive gagging of the media will be. Let us probe this matter together. Welcome to The Probe here on the JoyNews channel. We're also live on Joy 99.7 FM, together with a dozen affiliates across the country. Love 99.5 FM in Kumasi. Also on DSTV is channel 421, Go TV 144. Of course, we are available on myjoyonline.com also, and all our social media platforms. Tonight, the Information Minister, Kojo Oppong-Nkrumah, is my guest. Please stay. Welcome back and thanks for staying with us. Shortly, we'll get to the Information Minister, Kojo Oppong-Nkrumah. We're joining us live in the studios. But this week, there was a consultative forum on broadcasting. Amongst others, the Attorney General and Minister of Justice, Godfrey Adame, says the broadcasting law will not amount to censorship. And of course, the AG stated that at the Ministry of Information-led consultative meeting with broadcasters, it's aimed at generating a broad consensus to enact the law. But with some concerns that the bill, if passed, will limit press freedom, the Attorney General believes it's needed to regulate the media space. We'll hear from him and others at the forum shortly.
Whether this law is not going to amount to censorship of the media in a way. And I say that no, that's not at all. Because the Constitution itself, by its architecture, anticipates regulation of the media. And that regulation of the media is not unconstitutional. Because, as I indicated in my remarks there, Article 21, which grants unto us the fundamental human rights and freedoms, including the freedom of expression and the freedom of information, also anticipates that there ought to be a restriction of that in accord with the law. And that law ought to be for the purpose of ensuring public morality, public order, and health of society. Then Article 164, also after the grant of media freedom by Articles 162 and 163, also anticipates that there could be reasonable limitations imposed for the purpose of public order, public morality, and the protection of the reputations and rights of others. Now, so the point is that content is anticipated by the Constitution to be the benchmark for determining whether the freedom of the media has been abused or the rights of other persons have also been curtailed. So I'm saying that where the Constitution anticipates that the content churned out by the media generally ought to ensure a preservation of public order, public health, public morality, and also will guarantee the reputation and rights of others. Clearly, that injunction of the Constitution is in accord with the international standard. Internationally, across the world, content is the yardstick for determining whether there has been an excess by the media or not. So really, if there is the enactment of a law which seeks to give the fine details of what reasonably could be a limitation imposed on the freedoms enjoyed by the media, and especially when those limitations are clearly in the spirit of ensuring public order, public morality, reputations and rights of others, that will be in accord with the constitutional standard and also the international standard.
Crucially important is, long in coming. It's unfortunate that since 2012, the broadcasting bill has been incubating, awaiting birth, and the time to give birth to this all-important law is now, because developments on the media scene are so ugly. The unfettered freedom, and freedom everyone has no absolute value. But what is happening on the media landscape now suggests that media freedom has been taken for granted, especially those in the local language speaking stations do whatever they want to do. But we must commend them for giving meaning to the constitutional rights and sovereign entitlement of ordinary Ghanaians to receive information and disseminate same in their own language. This is a big plus on the part of the local language speaking stations. But on the flip side is the ugly spectacle, which calls for the enactment of a law like the broadcasting law. Social media has come to make the issue so complex and even worse, to the extent that socially determined content enables each and everyone to do whatever he or she wants to do on the media scene.
Is there no fear that this might curtail media freedom, that there may be provisions that at the end of the day will stifle media freedom and the ability for the media to operate without any interference whatsoever?
No, we need to look at all sides, because the freedom of the media is guaranteed, is enshrined in the Constitution. So there's nothing can be done, because any attempt to take away the freedom will consign this nation or the media to those dark hellish days in which we were enveloped in the culture of silence. We have come too far to go back.
So you heard there the GJA President, Afil Money, there at that consultative forum. And tonight, the Information Minister, earlier today, they issued that communique from that consultative forum. And thankfully, he joins us in studio. And also we'll take a look at that fine line between censorship and regulation as we put together that draft for the broadcasting law. Thank you very much for your time here tonight on the probe. It's good to see you. So earlier today, you outlined the communique from that consultative forum, and I know that a 13-member committee has been put together. First off, I would want to get an understanding of what exactly this committee is going to be doing.
So just to backtrack and put a couple of things into context, what we did last Friday was a consultative meeting that brought together about 13 different stakeholder groups to examine what is referred to as unethical broadcast content that is showing up on our broadcast platforms that many people express displeasure about, and to find the best legal way to deal with it. To find the best acceptable way to deal with it. Because when dealing with media content, if you are not careful, what you end up doing is that you end up infringing or clawing back on the rights to free expression, free thought, and free media practice. So it's important that you get all stakeholders around the table so that whatever we are doing, we all understand and agree that this is acceptable. Now, after several hours of deliberation, the stakeholders agreed that the best way to deal with what is unethical content on our broadcast platforms today is to A, allow the National Media Commission to be front and center in dealing with it, but B, be cognizant of the fact that the National Media Commission needs the augmentation of, may I say, resources or help from other stakeholder groups. And the NMC itself found that in Section 10 of the NMC Act, it has the power to set up committees made up of people from within and without the NMC for various purposes. And so the agreement was that, one, a memorandum of cooperation be properly executed among all of these stakeholder groups. That will spell out the arrangements that they will use going forward. Two, one of the key parts of this arrangement is that they will use the NMC committee under Section 10 and bring all the other stakeholders under that committee. So what is happening is that it's not government that is going to take any action. I've seen some reports this evening that suggest that government is going to do something. Government is not going to be the one taking action. The National Media Commission is going to be assisted by the stakeholder groups. What government did was to create a platform for all of us to have a discussion and see how to move. Now, this committee has representation from the National Media Commission itself, the National Communication Authority, the National Security Secretariat, the Bank of Ghana, because people are doubling money on television. That's our currency, and they have interest there. The Ghana Independent Broadcasters Association, so that all of us who are in the industry have our interest protected there. The Ghana Journalists Association, you just saw President Afomoni speaking, and then the Office of the Attorney General. Now, specifically, what they'll be doing is this. You know, when it comes to frequency utilization, the NCA is the one that gives you authorization to use a particular frequency. But we don't want a scenario where the NCA will start getting into content issues and Suomoto making a determination of what content is acceptable or unacceptable. And so this multi-stakeholder committee is the one that will, one, examine on their own, or two, examine reports of unethical content and then make recommendations to the regulators on what must be done. Now, if it is a matter that requires a warning, and same warning to be published, so if you say like a name and shame approach, then they will do so, issue the warning and ensure that that warning is published and everybody's attention is drawn to the fact that this media house has been warned for this particular kind of content. Secondly, what they'll be doing is that if it is content that needs to be flagged as unethical, this multi-stakeholder group again will be the one that will be flagging the content.
And they will be determining which content should be flagged?
Of course, because already if you look under Article 164 of the Constitution, it talks about the fact that the freedoms that we enjoy ought to be looked at within the ambit of 4 pillars: national security, public order, public morality, and things that are against the reputation, rights, and freedoms of other persons. What you don't want is for the NCA to on its own say that this one is against national security, so I've taken it off, or that this one is against public morality. So what this multi-stakeholder group will be doing will be to examine reports that do come in and to also on their own examine. Now, when they examine, like I said, they'll be making recommendations to the NMC and to the NCA. So to the NMC, those recommendations most likely will be recommendations for them to issue warnings, etc. Now, where broadcast platforms are refusing to comply with the recommendations of the NMC, as is seen sometimes when the NMC makes recommendations, they can go further to make recommendations, this time to the National Communications Authority that gave you the frequency, that authorization for you to be broadcasting. And those recommendations could include recommendations to suspend the frequency authorization that has been given to you, or recommendations that that frequency authorization should be withdrawn. Now, the NCA under Act 769 is the one that has power to suspend or withdraw those authorizations. But we have to be sure and to guard against a scenario where the NCA on its own voluntarily starts withdrawing or suspending. And that is why the stakeholders have agreed that they themselves will work with the NMC to examine the content. And if it is content that they find as unethical and content that they find as offensive to all of the other provisions, whether to the GJA rules or to the other rules that they have, then they will make the recommendations for the appropriate regulator to deal with it.
Okay, and they are supposed to start working within the next 14 days?
Within the next 14 days, they've agreed that they will execute the memorandum of cooperation that will spell out all of these details, and then they can proceed from there.
Okay, so these are some of the issues that people have started raising concerns with, issues about that fine line between regulation and censorship, and the fact that there are existing laws that we should be operating in itself before we start looking at the broadcasting bill. So it's a good time to start bringing in the questions. Then we can start interrogating them, because there are a number of concerns that people have with this. Because amongst others, you also looked at the draft broadcasting bill, which we'll be looking at as well. So if we're ready, let's get through the questions. So this one from Nabil says, ask Mr. Oponkuma how different this new broadcasting bill will be from the legislative instrument that the National Media Commission wanted to pass, but was struck down by the Supreme Court as unconstitutional.
Okay, let me take a few and then I'll respond later.
Exactly. So we have Hashmin says, find out from the Information Minister if they can assure Ghanaians that this will not be a move to try and dictate to the media what to publish and what not to. Leila says, are there not already many existing laws that can take care of the issues in the broadcasting space other than enacting a new and special law for it? Sheila says, in this country, there are enough laws already, and we continually pass new ones. The problem has always been about how to enforce them. What is the assurance that this time it will be different and we won't just add a new law to our books, but leave it to gather dust on the shelf? So I think we'll deal with the first one. So the issue about the LI 2224 is coming up.
So if you look at LI 2224, the view of the Supreme Court was that the concept, or what they considered as prior approval of content. You know, LI 2224 required broadcasting platforms to make a program guide available for approval. And the Supreme Court was of the view that this concept of prior approval of content was amounting to, or would amount to, censorship. They also, I think if I read it well, expressed the view that they did not think that by legislative instrument you could fetter constitutional rights. You probably have to come with substantive legislation under Article 164. Now, first of all, the broadcasting bill that we are currently discussing with stakeholders does not seek to do prior approval of content. It seeks to provide flesh to the issues that are raised under Article 164, national security, public morality, the reputation, rights and responsibility of others, public order. It seeks to give expression to those, or to flesh to those, so that if you deliver content that finds itself in breach of those, then action can be taken, but not as though you have to come for prior approval from the NMC before you go into those areas. That's one of the major differences. The other difference is that the current instrument we are looking at is a bill which will become an act and not subsidiary legislation, as in something that a minister may by LI lay in Parliament for 21 days and then it matures into a piece of legal instrument. But I think it's important to say that we are still at the discussion stages. So a lot of issues are up in the air. It was a very, very healthy discussion on Friday. Many areas we had agreement, some areas we had disagreement, and now they are sending us written memos to provide, and sometimes even among the stakeholders, they disagree on how, for example, the concept of two-tier authorization should be operated. In some jurisdictions, let's say like the UK, you have one regulator, like Ofcom, which will deal with your content and your frequency allocation. In other jurisdictions, you have two regulators. One will deal with content, like the NMC, and then you have NCA that will deal with frequency. There are those with the policy proposition that in the new bill, we should just give the frequency powers to the NMC, so that when the NMC examines your content framework and they find it suitable, they can proceed to give you a frequency to work with. There are those who even hold a different view, that it should be the other way around, that still come to the NCA, but just go through the NMC first before it comes. So even among the stakeholders, sometimes there are differences. The idea is for them to be able to furnish us with these views, and as we consult other experts, etc., come to the executive's position and then go to Parliament. But
one concern, for instance, is that to the extent that NMC went to court the last time on this, the Supreme Court ruled that it amounted to censorship in terms of what they brought to them. And we have the NMC still making input into this broadcasting law. Are we not reintroducing, this regulation that we know that will not stand the constitutionality test?
So I think the question also is, what did they include in the LI? How much consultation was done? What is being proposed in this substantive bill? How much consultation is being done? So that the parts of the LI in particular that Giba, for example, was unhappy with, that the courts have held, can be addressed as we look at a substantive legislation to deal with broadcast regulation and some elements of content issues. So I'll be surprised if the same challenge is repeated, because this time around we are having very elaborate consultation and a lot of inputs that are being made to ensure that the challenges that were occasioned by the first route that they took, which was this prior approval or prior authorization of content, are dealt with. The second question about would it not amount to dictating to the media? Nobody can dictate to the media what to publish. You know, the media sector is one of the most vibrant and academic sectors. Freedom of media gives everybody who is in the space the right to publish that which they ought to publish, save for some specific instances. What this broadcasting law will seek to do will be to flesh out those exceptions properly so that we in the broadcasting space are guided not to go into those areas. It does not mean that, like what happened with the LI, it is going to be a regime where before you even put together your content, you have to, as it were, get prior approval or something.
But when you put out the content and it is decided that this one is not supposed to be there, so your license will be revoked, how are we hoping that all these will be streamlined properly?
Today, the laws exist for the suspension or the withdrawal of your authorization. If you publish content or if you broadcast content that is found to be egregious against the terms and conditions of that authorization. One of the gaps that we have today is who makes that determination. And I applaud the stakeholder forum for solving that problem.
How do they solve it?
Because traditionally, the NCA is the one that made that determination. And they have had occasion to do it once. They got it right in that particular instance, in the case of Radio Tong in the Volta region, which was promulgating or advancing the cause of secessionists. And they took a decision to withdraw that frequency authorization. And when the operators of the station went to court, the court ruled against them, that indeed what you were doing was against national security interest. But fancy a situation where you have an NCA that chooses to do something funny. Then they could stretch their arm a bit too far and begin to interpret content as against national security, against public morality, against etc. So the very intelligent answer they have found is now to have this committee under Section 10 of the NMC's rules, which now require that they themselves, with everybody there, GJ, Gibba, everybody there, will have an opportunity to examine the so-called content that is being complained about and make recommendations.
So this committee is drawing powers from where? From the NMC?
Yes, from Section 10 of the NMC Act. And when they come to the view that indeed this is against the interest of X or Y or Z, then they may proceed to make recommendations. Those recommendations, as I mentioned, may be warnings, they may be naming and shaming, they may be to draw the attention of the National Communication Authority that we are satisfied that this particular content goes against these ethical provisions. And we think that to the extent that this person, after 30 days of this warning, is still continuing or persisting, action must be taken. So it is within that framework that you can be hopeful that not the minister, not even the NCA, but the NMC and all these stakeholder groups that I've outlined earlier can look at issues dispassionately and act. So they can balance the protection of our freedoms with media gatekeeping, which is something that is done all over the world.
So Leila and Sheila almost has the same question. Are there not already many existing laws that can take care of the issues in the broadcasting space rather than enacting a new and special law for it? Sheila is also raising the concern about adding a new law, which will just gather dust on
I think the question of enforcement is a very valid question. We have a lot of laws in this country that could have been better enforced. And I think even in this particular instance, we have had cause to argue that there is a lot of legislation today that can be applied. And I think what has happened is that you have seen the stakeholders find a way to apply what exists already. But what exists already is not sufficient to deal with a comprehensive regulation of the broadcast space. Because today you have about 2 different pieces of legislation. The NMC Act, the NCA Act, spells out different functions, and you have gaps in between. So as much as today there's legislation that is good and can be better enforced, there are still gaps. What the broadcasting law will do will be to close those gaps in terms of regulation of the, or in terms of management of the regulators. So that if you, because today when you apply for a license, You state some content issues. You attach sort of a business plan and outline some content that you desire to do. The NCA purports to do an analysis of that. Are they really the best placed entity to do that? And then they will proceed from that to now do the frequency analysis, and then if they find it favorable, give you a frequency. And the NMC is literally a stove that is sitting somewhere and has nothing to do. And if you don't take care, the NCA will also now start looking at issues of content. And that is why you need comprehensive legislation that cleans up those gray areas and spells out the relationships even between these two regulators, as has been done in other jurisdictions. So there is law, but it's not comprehensive enough, and that's why it's important to tidy it.
So you don't think that we're burdening ourselves with more laws in dealing with this? Because you've mentioned a number of things that has already been done with the existing laws. Yes. Some actions being taken to sanitize the space already. Yes. Why then do we need it?
The existing legislation, for example, does not spell out the relationship between the NMC and the NCA. And it literally now puts a two-tier or a divorced structure in place where somebody gives you frequency, somebody looks at content. If you look at jurisdictions like the UK, they have moved from there. Okay. They have actually one entity that will receive the complaints and exact sanctions. You've seen, for example, quite recently when COVID came, I think Pastor Chris Oyakilome or so, involved in content which was viewed as unethical. The Ofcom is the one that received the complaints, investigated those complaints, and proceeded to sanction. In our jurisdiction, you don't even have the kind of collaboration between the regulators to do this. And so it is for that reason that you see all the things that have been going on our screens and on our platforms that people are complaining about. Okay. Why you need a comprehensive broadcasting legislation is that, among other things, you can then, for example, 1, tighten up these relationships, 2, spell out the parameters of what, for example, the NMC tried to do on their own through LI 2224. You can now properly spell out those parameters by substantive legislation and a route that does not require prior approval as the court saw it, and therefore clean up the space without infringing on the rights.
So with the draft proposals that we have so far, are we going to get a special entity for that, or we're going to empower both of them? What exactly?
We are, I mean, the discussions ongoing are about tightening the relationship modules between the two entities so that the kind of collaboration that you desire from amongst them to get the results you are looking for can take place.
Okay, so we'll get into the next part of questions, but before the consultative forum started, listening to you, there were some 5 key questions that you thought needed answers to. At the end of it, maybe I'll just go through the questions. Who determines what is inappropriate? What is inappropriate? How do we determine what is inappropriate? And then the legal tools available in the interim and what remedies are available. These are some of the questions that you posed. 5. At the end of it, did you get answers?
Yes, I think the forum answered it. So, for example, the forum determined that the best person to determine what is inappropriate is the National Media Commission.
Okay.
It does not lie within the mouth of government or civil society or somebody to say that this content is inappropriate or unethical. The NMC is the best vehicle to do that. But they also acknowledge that the NMC needs augmentation and support and other perspectives. And that's why they said, then why don't we all come together and work with the NMC to make this determination? And so that's why they are going under the Section 10 committee of the NMC to assist the NMC to make this determination so that it doesn't lie in one person's mind.
But if Section 10 is already there for the NMC, how come they were not implementing it?
Well, we've had some disagreements, you know, even within the industry. If you recall, I have been one of those who've disagreed that it cannot be that the NMC is totally helpless. There is today room for them to collaborate with other regulators and achieve results. And the NMC was very insistent that this is our space in terms of media content, may I say assessment or determination. But we acknowledge we don't have the power to take some punitive sanctions. The NCA may be the one to have the power to do that. And so the question now becomes, how do we build that collaboration? Which is what I think, they've succeeded in finding a nice route around.
Okay, so NMC will determine what is inappropriate and how we determine it. That has also been fine-tuned.
Yes, and then in terms of the legal tools, that will be sitting within the NCA Act 769, and then the NMC Act itself, I think Act 449. They now have clarity on when to use what tool among themselves as stakeholders.
Okay, we'll get into the next part of questions at this point. We have a number of questions. So Lovia says, I understand this broadcasting bill has been in the works for a while now. Indeed, Mr. Oponkuma inherited it from the previous government. What was the state of the bill? And has there been any changes to what Kojo originally came to meet? If so, what were these changes and what necessitated them? Lovia is asking. Emmanuel says, will this new law continue to separate the National Communications Authority and its power to grant and revoke authorization and licensing and maintain another body like the National Media Commission to regulate content, or will harmonize such duties for one body to operate? Loaded. Rankman says, what does Kojo Oponkuma think about the European Union Election Observer Mission's proposal that the power to authorize and revoke broadcasting authorization be taken from the National Communications Authority and handed to the National Media Commission? Bismarck is asking, on the scale of priorities, how important is this bill to the Information Minister, and how soon will the bill be presented to Parliament for the legislative process to commence? Okay, so we'll take it from Lovia. Lovia started this batch, and it says, I understand this broadcasting bill has been in the works for a while now. You inherited it. What are the changes, and what necessitated those changes?
Well, so we are in the process of discussing what we call emerging issues. We haven't made changes to the draft that we inherited.
Okay.
After we went through the first round of consultations, what we did was to identify what we call emerging issues, and to engage stakeholders on what policy propositions they think should be adopted on those emerging issues. And for example, I'll give you a few. I think I even highlighted them in my opening remarks. Take broadcasting. So broadcasting is traditionally defined as the dissemination of audio or visual content from one to many, using what they call spectrum, and typically they refer to radio and television. But for purposes of the content in it, audio and visual, technology has gone beyond radio and TV. And today you have what they call OTT or IPTV. So as we are broadcasting today on traditional television and radio, we are also broadcasting online.
The internet.
So if you restrict the definition of broadcasting to radio and TV, and even agree on standards, what happens when somebody is bypassing all of those and doing this on OTT or on IPTV platforms? Should the same rules apply? Of course, when it comes to the technology-related matters or authorization, they may not be the same rules because it may not be a matter of spectrum or frequency in the digital space. But assuming you get into the space of standards, what happens when you get there? So should the definition of broadcasting be expanded to include OTT or IPTV? Very interesting views were expressed. They are sending us some written memos on it. We're not in a haste to, make a decision, but it is an emerging issue that must be thought of both in an academic and a practical sense, so that we don't enact legislation that is moribund from day one on which it came. I'll give you another example. So we have what we call community broadcasting in the draft bill we inherited. But that community broadcasting bill, or the sections that deal with community broadcasting, we're looking at issues of frequency authorization for community broadcasting. But of course, your content and other matters are the first parts of your application, which define it as a community matter.
Okay.
So there's not commercial broadcasting, etc. Now today, a new pattern is emerged where if you come to the villages, we have what we call the local information center. That is also involved in some sort of broadcasting. Do the same rules apply? Apart from the question of frequency, etc., all those issues about standards, etc., do the same rules apply, or should they not apply? The things that perhaps you are not able to do. So today, everybody is complaining about money doublers, etc., happening on mainstream TV, and are asking the regulators to act, assuming they are minded to act. But somebody is doing it on the local information center. Do the same rules apply? Or should the local assembly or somebody else be the one empowered to act? These are things that we must exercise our minds to. For example, when you are publishing a newspaper today, you know the rules in Ghana that you have to register with the NMC. It's not a license, but you register with the NMC. How about if you are publishing online? Do you have any obligations to also at least register. Why do you register with the NMC? So that if somebody makes a report of an infraction against journalistic standards, the NMC can invite you and do an investigation and find out that you did nothing wrong, you were right, or that there was something wrong and say maybe render an apology or something. Should at least that same benchmark be applied into the online space? There's one very controversial one, there are two very controversial ones. As we are on television, if you were to activate your phone lines and somebody were to call in and make comments that were defamatory or against national security interest, you will quickly moderate it. You take it off, issue a disclaimer. Why? Because you are aware of the ethics and the principles of the profession, and so you are quick to ensure that they are upheld. In the online broadcast space, when people come and do the same, do you have the same obligations? Should you have the same obligations? So all of these are new emerging issues that we have had to draw the attention of stakeholders to. That. What are your thoughts on these ones as we try to make policy? What are your thoughts on it? So that we can find what we believe will be a decent middle ground and possibly include in this final draft.
And what were the initial inputs on
diverse views? Diverse views. And again, I don't think that at this consultative stage it is fair to even go into them.
Okay.
But diverse views, very rich academic and practical views of what can be done, what has been done in other jurisdictions that has succeeded and has failed. And therefore, we are hopeful that by the time we are done with these consultations, it will inform some of the provisions.
Okay. And then Emmanuel raised issues about separation of the National Communications Authority and its power to grant and revoke authorization and licensing, and then maintain another body like the NMC to regulate content, or will you harmonize such duties for one?
In the draft and in the discussion so far, I have not come across any suggestion that it should be harmonized.
Okay.
It is rather the level of play and the relationship between them that you find various suggestions. Some of the civil society groups look at it in one way, particularly those in television, who are arguing that today television is moving away from, how do I put it, spectrum authorization to more of multiplex operations, where you have, let's say, an operator who has 10, 15 channels and then people put their content on it. And therefore, the same arguments may not apply. So even in that space, you have some divergent views. But the idea is to interrogate this some more and then come to a certain common point, which we can then advance into a policy proposition.
Okay, so Rahman has a question about what you think about the European Election Observer Mission's proposal that the power to authorize and revoke broadcasting authorization to be taken from the NCA and handed to the NMC.
I mean, I think it's a proposal. I am somebody who very much believes in our sovereign position as a country. As much as we respect what other people say, I am not sure that they will be making their law saying that, you know, the African group thinks that we should do so. So I think sometimes we should tone down on trying to compel ourselves with what somebody else says of our country. The substance of that suggestion is a position that finds favor with some groups, that actually that is the way we should go. And then there are those who disagree with it. But like I said, it's early days in this conversation, and our objective is to examine the various propositions, the pros and cons of same, and then make a decision based on that.
Okay, so on the scale of priorities, how important is this bill to the Information Minister, and how soon will the bill be presented to Parliament for the legislative process?
It is one of the two pieces of legislation that we expect to go to Parliament, hopefully in this meeting with. The other is the legislative instrument on the Right to Information Act, which currently the ITI Commission is engaging stakeholders to come to us with an initial draft of, and then we can work around that draft and then go to Parliament. But because that is legislative instrument, hopefully 21 days after its laying, if there are no objections to it, then that can pass. But this is one of the two pieces of legislation that falls on our table. And in this meeting, we hope to make some progress with it.
We were promised it was going to happen in 2020. What happened?
I don't recall who promised 2020. I inherited the bill and we worked on it up to the end of 2020, but it could not find expression in the legislative agenda. By the grace of God, we are back in power. By the grace of God, I remain Information Minister. I have the opportunity to take it forward, except to say that when Parliament is not able to conclude on a piece of legislation within its cycle, you literally have to start the whole process again, and that's why we're having to deal with some of these.
Okay, so James here sends one that we'll have to go for a break, but when we return, James makes reference to the exact place that you made that comment that it was going to be passed before the end of 2020. But I'm sure once we come back from the break, we'll take a look at it, then we'll get a response from the Information Minister. Welcome back and thanks for staying with us here on The Probe. We're live on the JoyNews channel, also on Joy 99.7 FM, affiliates across the country. And of course, we are live online as well, since we've been talking about that, and all our social media platforms as well. Thanks for staying with us. Information Minister Kojo Oponkoma is our guest. We've been looking at the consultative meeting that was held over the week, and then also the draft of the broadcasting bill. That fine line between censorship and regulation is what we've been looking at, and your questions have been coming in as well. We'll get into the next batch of questions at this point once we're ready. Let's go into it. So James says Mr. Oponkoma announced in 2019 at the celebration of the International Day to End Impunity for Crimes Against Journalists that government intended to pass the same law before 2020 ended. What happened to that promise, James is asking. Felicia says, why do we need this law when we can empower the NMC to play its roles? And Faustina says, what is the buy-in of the opposition NDC on this, especially the Communications Select Committee in Parliament? So we'll take answers to this batch, then we can get into more. So James is making reference to celebration of International Day to end impunity for crimes against journalists.
He says at that time we said the government intends to pass it in 2020. I don't quite recall, but I mean, even if government expressed an intention and I didn't see the light of day, thankfully we're here and we're having an opportunity to complete work on it. But I don't recall that specific. I think the other question about don't we have enough, what would this new do? I think I've answered that already. In terms of buy-in of the Communications Select Committee of Parliament, well, we are yet to appear before the committee. The process of lawmaking is that the executive makes legislative proposals to Parliament. Parliament is the one that makes laws. I've seen laws that come to Parliament or bills that come to Parliament, and the bill is the proposal of the executive on how to deal with a particular mischief. If you look at, I think, Article 103 or so, that spells out how to make laws. Yeah. But when it comes to Parliament, and once it is in the hands of Parliament, and Parliament is seized with it, Parliament can choose to do with it what it desires. But what an executive must do is that before you go to Parliament, you should broadly consult and engage with various stakeholders. That, for example, these are the issues of mischief that we desire to deal with. And these are maybe even our proposals on how to deal with it. What do you think? Because laws are made for people. You can't make a law that the people are not comfortable with. And so our process is to engage broadly and to give the stakeholders an opportunity to weigh in on, for example, some of the policy questions that have come up. And you will find that there are a lot of stakeholders, for example, who, when you put this before them, they say, wait a minute, actually this is true. Then maybe we should include this under the Broadcasting Act. Or no, this can go too far. Let's take that out and deal with it with a separate piece of legislation. So that the piece of legislation that you eventually take to Parliament has a higher chance of success and lower chance of obstruction. We expect that when we get to Parliament, we'll have an opportunity to engage broadly. But this is one piece of legislation that I'm hoping that we can all, in sincerity, work on in good faith. Okay. And examine what is becoming of our landscape, our broadcast landscape, and agree on what must be done about it. We win together, we swim together, we sing together.
Okay, so beyond these 13, institutions or those you consulted with over the week, do we have plans of consulting wider beyond these, institutions?
Principally, these are the key stakeholders in the sector. But I think, as the communique mentioned, there was an agreement that we need written memos on some of the propositions. And even as I'm here with you this evening, I'm getting messages from other groups that would want to weigh in on some of the propositions. And I've just explained to them that we will make it available and request for their views on some of those policy propositions, so that in the end, when the executive is making up its mind, it has considered all of these views and has come to a certain position, which position it will then take to the legislature as its proposals to be enacted into law.
So at this point, which stage would you say we are exactly with the draft bill for the broadcasting law? You'd say?
I think that we're about 75% there in dealing with the broad strokes of the issues. There are emerging issues that have come that we, have raised to get some guidance in constructing the executive's policy propositions on. Our expectation, and again, I think we should be quite clear, our expectation, our intention is that by the time Parliament resumes in May, we should be in a position with what is left of the work to be done to lay it before Parliament, for Parliament to also start its own, because typically what will happen is that Parliament will also do its consultations and hear people that what do you make of the executive proposals, do you have memos on it, what do you think? They may fetter what we've sent in, they may agree with it, they may even disagree with it. If you take the RTI bill, by the time he arrived in Parliament, the Honourable Frederick Opare-Ansah, MP for Suhum at the time, is the one who led the changing of a good chunk of the structures to even allow us for a 6-month period to begin to put the structures in place. That was not in the contemplation of the executive when the bill was being brought to Parliament. So I think we must also understand the process for lawmaking and flow along with it. One final thing, sometimes in the process of lawmaking, when you engage stakeholders, some of them take it as this is the executive's position on the matter and go to town that the executive wants to make a law that will do X, Y, Z. But we must understand that it ought to be a consultative process. And what you have to do is to come to the table with your thoughts and your views on a particular matter so that in the end, the executive is guided in making its policy propositions known to Parliament, but not to take it as though, this is what they want to. Because sometimes, as a policy maker, despite what your technocrats may even come up with, that, in Australia, this is how they've done it. In UK, this is how they've done it. Here, this is how, South Africa, this is how they've done it. So this is how we should do it. When you now take that and you sit with the stakeholders and say, this is the draft as I have inherited. What do you think of this? You also get to learn and see new perspectives, which can then inform what has been done. So I think we encourage all persons to participate in the process.
Okay, so any individual can also send in proposals?
Absolutely. If there are things that you think must be contemplated and legislated upon while we are doing this broadcasting bill, please feel free to send it to the Ministry of Information through any of our communication handles as advertised on our website. Okay, so in all this, there are some key questions that some viewers, for instance, pose. One interesting one I heard was that as a viewer, should I not be giving that right and free will to decide what I want to watch? If I know, for instance, that I go here, this is what I will get. I go there, this is what I will get. I either go there or not go there. That's one of the concerns that one person raises for instance. Yes, that's a genuine concern. But every society, while agreeing with you that you have the right to choose, and even sometimes because of age stratification, say, okay, this is restricted 18 and therefore it will air at this time, etc. Or this one is on a pay-as-you-go platform, or pay-per-view platform, etc. While all of that exists, every society also draws a line in the sand on what cannot be shown on broadcast platforms. I'm not sure you can say that you want to watch a show on babies being raped or children being raped on television because that is your desire, you want to watch it. So there will be some limits that every society will draw the line in the sand that you can show and watch all things, all of these at these times, but these go beyond the border. And for us as a society, we think that it ought not to be allowed. And those are determinations that the National Media Commission, one, has to make, but make based on law. That is why the first time they tried it through an LI, they had challenges. They have to make them based on law. And two, when somebody claims that Kojo's show is offensive to national security, it ought not to lie in there, because then somebody could use it as a ruse. It ought not to lie in the mouth of one person to say, it's true, it's against national security, take it off. You must have a certain platform for making a determination, platform where the interests of various groups are represented, to make a determination that indeed this is as it is, and therefore make that invocation or recommendation to the National Communication Authority to act accordingly. So largely, you disagree with the view that regulation starts with the viewer? No, the Constitution is quite clear that the freedoms that we have are not unfettered. But it's quite clear also in saying that they can only be fettered based on some principles. Our job is to do legislation that spells out and explains or gives life or flesh to those principles so that everybody is clear in their mind. One of the other arguments that is made is that self-regulation is the best form of regulation. But if you've studied what I call society dynamics, or what they call society dynamics, deviant behavior, it cannot be that everybody in the society will agree that this is how we self-regulate on this matter. No, you will find people with different thresholds and different attempts to go beyond certain barriers. What the society has to do is that within the framework of what the Constitution has provided, national security, public morality, public order, reputation, rights and responsibilities of others, how do we provide a framework that guides everybody that this is where we can play?
Well, so the issue also about social media, we know that maybe the previous draft didn't really cater for that. So if we are regulating the mainstream, traditional media and all, how are you making provisions for YouTube, for instance? Because if I don't get it on the mainstream, I can get it there.
So it is one of the areas that we have thrown to the industry players to give us their perspectives on. That is why I raised the question to you earlier, that if we agree that what we are doing is broadcast on radio, same content, TV, same content, online, same content, and we agree that there are some...
In the case that it's not the same content, for instance, we are not streaming the same content out there.
I'm coming to that point. We are agreeing that there are some levels of content that within the frontiers or the barriers of what the Constitution talks about, which we are talking about, ought not to be aired, whether on television or on radio. Then the question becomes, so can they be aired online? You've talked about YouTube. There may be other technology platforms. But the question now becomes, can they be aired if they are unethical to do on these mainstream platforms? Does it mean you can do it on those platforms? And if we are of the view that the same rule must apply, that which you can't do on television, that which you can't do on radio, you ought not to be able to do it within the jurisdiction on... I mean, let's be specific. Take these examples of money doublers on our television platforms that everybody is, talking about. 2 years ago, when we started writing letters to the NCA and the Bank of Ghana about it, a lot of people, were like, oh, let them be. Now the challenge has become more dire, and we're speaking about it. Supposing the NMC comes to the view that that is unethical content, it should not fly on TV, it should not fly on radio. Should it fly on YouTube? And how do we address that challenge? So let's think together. Let's talk together.
We have the capacity to do that.
Capacity is developed. We first of all have to have a conversation about how do we address it. And if we decide that, okay, this is the route to go, we can examine whether or not we have the capacity to deal with it. But I think the point is that we ought not to play the ostrich. We ought not to throw our hands in the air that nothing can be done about it. We ought to be guided by the risk of not going too far to clamp down on or to claw back on the freedoms that we all enjoy. So within that space that we can operate, let's examine what we can do. And I think that's the invitation that we have put out there by commencing these consultations.
Okay, so whilst wrapping up, whilst convincing those who are still of the view that this might infringe on the rights as enshrined in the Constitution, there are those who also feel that we should be setting realistic ambitions. In wrapping up, maybe you can speak to it briefly.
Well, I think what we'll try to do will be as realistic and as doable as possible. I have operated in the media space for over a decade, and I hold those freedoms very dear. The president, who is our boss, holds them perhaps even dearer than I do. We are minded that we ought not to claw back on our freedoms.
Okay.
But we are also guided that the floodgates cannot continue to be left ajar as they are. Where we find the middle line is what we're all having to have a conversation about.
We're grateful for your time. That's the Information Minister, Kojo Ponkroma, joining us tonight on The Probe. I am MFR Pau. Thanks for your company. There's more news when you log on to myjoyonline.com. A Walk with Jesus is up next for those radio audience. Thanks.